Look, I'd like to welcome our next speaker, Lisa Hanson. Lisa is a Wellington barrister and has a general civil litigation practice. She specialises in public law, medico-legal, employment and relationship property disputes. Lisa has served as a Crown Counsel at the Crown Law Office and worked for the Department of Conservation in Hokitika, as well as private practice. Lisa is here to represent the New Zealand Health Trust, an independent charitable trust to educate New Zealanders to make informed decisions about their choices of health and well-being. So if you could welcome Lisa to the stage, thank you.
Kia ora tātou, everyone, and thank you, Glenn, and thank you in particular to Paddy and the Natural Health Alliance for organising this meeting. So as Glenn said, I'm here as a lawyer representing the New Zealand Health Trust, which is a consumer-focused organisation that's been actively opposing draconian over-regulation of natural health products since the mid-1990s. And I just want to briefly cover 2 points. First, I want to provide a potted and high-level summary of the history of the various attempts to regulate natural health products over the last 40 years. And second, discuss the right to health and how that right is being breached by the bill. So first, some history. The Ministry of Health, as Paddy alluded to, has been endeavouring to regulate dietary supplements and natural health products as a subset of medicines since effectively 1984. The good news is that they haven't succeeded yet, and that has been largely due to strong consumer and industry opposition and effective political lobbying, as Guy Hatchard sort of explained in relation to the 2017 bill. So this meeting is timely because the bill has not been passed into law, and there is still an opportunity to get natural health products out of it, and we have history on our side. So starting with the dietary supplements regulations, 1985, initially these were going to be regulated under the Medicines Act. However, ultimately the government regulated them under the Food Act, as Paddy said. And the explanatory note to the regulations is interesting because it recognises that dietary supplements are almost a unique category of product. It says, and I quote, "These regulations, in a sense, fill the gap between the Food Regulations 1984 and the Medicines Regulations 1984, in that dietary supplements are not food or medicine in the ordinary sense of those words. However, they are food within the meaning of the Food Act and will be related products within the meaning of the Medicines Act if therapeutic claims are made for them." So that was the explanatory note. So moving now to the 1990s, the Australian Therapeutic Goods Act had come into force, and the focus in New Zealand became on developing a Therapeutic Products Bill in alignment with the Australian Act. And it's important to note that the Australian system for regulating natural health products is one of the strictest in the world. For example, it only permits products to be sold which have been listed on a register. The products can only contain approved ingredients, so there's a white list, and you can't make claims unless approved. So a lot of those features you'll recognise in the current bill. So at the time, this was back in the mid-90s, there was a public consultation on a proposed Therapeutic Products Bill that would include dietary supplements. There were some 9,500 submissions made, I understand, and the overwhelming majority of those opposed the inclusion of dietary supplements. And then by 1998, effectively, the plan to introduce such a bill was abandoned. However, the plan to work in tandem with Australia was still live, and it remains live. The next pivotal event was in 1999 when the Australia-New Zealand Therapeutic Products Agency, also known as ANSPA, was created. And the overall goal was that Australia and New Zealand would harmonise their legislation for prescription medicines and medical devices and dietary supplements to reflect the Therapeutic Goods Act. A treaty was signed between Australia and New Zealand in 2003 for the creation of a joint agency to regulate therapeutic products, including dietary supplements, and that was going to be based in Australia. So all this led to the preparation of a Therapeutic Products and Medicines Bill to align with Australia's TGA Act. This bill was introduced into Parliament in 2006 and included natural health products. Now, the bill was very, very unpopular, and there was strong and vocal opposition to it. And the key issues that ultimately saw it not get to a second reading are really some of the issues that arise with the current bill, basically the cost to implement the scheme, the impact on rongoa Māori practitioners, and also widespread concern that access to natural health products will be jeopardised. So the Therapeutic Products and Medicines Bill was gone by 2007, and in 2008 there was a change of government to the national government. Now, the chairman of the New Zealand Health Trust, Dave Sloan, was heavily involved at that time, and he says that while in opposition, Tony Ryle said to the industry, come up with a proposal in relation to natural health products, and when we're in government, we'll implement it. So the industry got together and in 2009 presented a JIP, a joint industry proposal for the regulation of natural health products. They presented it to Tony Ryle, who by then was the Minister of Health. So the JIP was a model of regulation that was very much focused on being cost and risk proportionate, something that is completely absent from the Therapeutic Products Bill, and it was a light touch in many ways. And some of the features of this alternative model include establishing natural health products as a separate category of product from food and pharmaceuticals, implementing a regulatory management system that was commensurate with the risk of the products, including just a simple product notification system, which would notify both products and ingredients. Evidence-based health claims would be permitted, and there would be provision for audits and post-marketing testing and so forth. So the industry accepted the invitation of Tony Ryle to produce this bill. They did actually draft a bill, provided it to him, and National, rather than using the JIP as a model for regulation, instead introduced the Natural Health Products Bill in 2011, which was vastly different. So in terms of the Natural Health Products Bill, as many will know, it was controversial and effectively incorporated the TGA model of regulation. As Guy has already said, in an extraordinary stroke of good luck, the bill was ditched by the incoming Labour New Zealand First government in 2017, and for that we do owe a huge debt of gratitude to Winston Peters. Then most recently, in 2018, a Therapeutic Products Bill was released for consultation on the express basis that it regulated medicines and medical devices only, and that natural health products would not be included and would have their own separate legislation. However, as we know, in 2021, the government did a volte-face and decided to include natural health products in the Therapeutic Products Bill, and here we are. And basically, the bill, to the extent it relates to natural health products, rehashes the earlier failed Natural Health Products Bill, but is also much worse because it places natural health products in a regulatory regime with medicines. There really is nothing positive that can be said about the bill. So that's the history. We've got a failed proposal in the 1990s to develop a Therapeutic Products Bill, a failed Therapeutic Products and Medicines Bill, never got to a second reading, and we've had a failed Natural Health Products Bill. However, concerningly, the 2003 treaty with Australia remains on foot, and the risk of a joint agency with Australia has not gone away. And if the bill is passed, then effectively there will be little difference between Australia and New Zealand regulation of therapeutic products, and therefore potentially no impediment to the establishment of a joint agency. That's the bad news. So the other thing I wanted to just speak about briefly was the right to health, and explain how the bill infringes the right to health. So this is a point the New Zealand Health Trust made in its submission to the Health Select Committee. I hope they were listening. The genesis of this right dates back to the World Health Organization Constitution, which was adopted in 1946, which states that the enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being, without distinction of race, religion, political belief, economic or social condition. And health is defined in the preamble of that constitution as a state of complete physical, mental and social well-being, and not merely the absence of disease or infirmity. Now, a right to health is recognised in Article 12, subclause 1 of the International Convention of Economic, Social and Cultural Rights, and it provides that everyone has the right to the enjoyment of the highest attainable standard of physical and mental health. And obligations on states include taking steps for the prevention, treatment and control of diseases, and states are also required to respect the right to health by not interfering with it, to protect it from interference by third parties, and to fulfil these obligations through legislative, budgetary, judicial or other suitable measures. So the right to health is recognised in Article 12 of the Convention. Section 8 of the New Zealand Bill of Rights Act, which is the right to life, may also incorporate a right to health. So the general argument as to how the right to life is breached by the bill goes something like this. So natural health products are, as their name suggests, natural. They're comprising principally substances from nature and are health supporting. And they contain ingredients which have a long history of safe use. Natural health products are widely and safely consumed in New Zealand to help support and maintain health and prevent disease. And New Zealand Health Trust says that the bill would unlawfully and unjustifiably infringe the right to health because it imposes substantial and onerous new layers of regulation that would inevitably result in significantly reduced access to and availability of safe natural health products. So in other words, the bill constitutes a direct challenge to New Zealanders' right to attain the highest standard of physical and mental health because it will interfere with consumers' freedoms and right to self-determination, freedoms and rights that they currently enjoy.